Okay, I wanted to talk to you today about a plan I've come up with that I think has the possibility of getting you on the IRS's most feared list. A couple things I learned about what's going on in the court. Um, I read a law review article written by a new federal judge, and I think it was a she who said that as soon as she got on the bench, that in her courtroom there was 5,000 motions pending, awaiting a ruling. Another federal judge in a law review article described being in trial, and while he was in trial, uh, all of his assistants would wait in the hall for him to get out of the trial, and then they would all line up and they had questions about what they were to do with different aspects of running his court. And then I read a district court decision where a district court judge was lamenting the cases that were languishing on his docket and how some of the litigants in his courtroom did not seem to understand, his plight. And then it got into, I was down at the law library and I noticed in the USCA, United States Code Annotated, that there was an entire volume on the judicial emergency, and I perused it, kind of looked through, and what it was devoted to was how they were going to handle a um, a crisis regarding assets. In other words, they only have so much resources to handle all the cases, and so they were suggesting here's the way we're going to handle, you know, the Congress not funding us, not providing us enough courtrooms, enough judges, and so forth. And so they got that going on. Then I read this book, The Price of Loyalty. It was Paul O'Neill, who was George W. Bush's first Secretary of the Treasury, and he described an attempt to get the Securities and Exchange Commission to work with him to hold executives of various corporations accountable, and he was unsuccessful, and he ended up concluding that the reason he could not obtain to his goal was because no one wanted the slightest uptick in litigation. So here's the federal government, the U.S. Supreme Court called them the most well-funded party that appeared before them, and yet they don't want any more litigation. So let me tell you about those of you that know me. I have a package I sell that has to do with I call it the calling off the dogs package, and basically it's all the research I did on Section 7433 suits for unlawful tax collection activity. The whole premise of that package was we're going to write a competent letter threatening to sue and get them to deal with it administratively. Well, varying degrees of success with that. Some people actually got wrongfully levied funds refunded, and others were able to stop levies using that strategy. There's a litigant in Texas who actually sent the notice, waited the requisite 6 months, and then he filed suit. And he had quite the report about what happened after he filed the suit. All the people in the IRS had a distinctive attitude change. They immediately gave him a $40,000 refund that they were refusing previously to give him. And then that was followed up by a motion to dismiss. The case was now moot because he had his $40,000. And the judge was not amenable to that. He denied their motion, and he made them stay in court until finally they came up with a settlement offer that he was amenable to. But he said that the Department of Justice treated him with the utmost respect, and that the attitude change in the IRS was, as a result of him suing, was notable. So he saw some pretty good results out of actually filing the suit. So that brings us to uh, a guy that I was able to make an acquaintance with, retired Patriot attorney Bill Drexler. He got up there in age, and one of the last times I talked to him, he was like, "I don't even want to talk about this anymore. I don't want to help anyone. I don't want to discuss it or whatever." But one of the things that he did say, he was pretty sharp, had a sharp legal mind. I think he was actually disbarred, but he still, spent a lot of his time helping people. And what he proposed to me back then was filing FOIA suits. And he says, the courts have jurisdiction over it. And what you're going to do is you go into the court and you say, hey, they ain't doing it right. That was kind of his line, was they're not doing it right. And, he thought that there was a reasonable opportunity to get a favorable outcome out of that. Pursuing it that way. So then that brings us to the IRS. The IRS is always, I've seen it in the Internal Revenue Manual, where chief counsel tells people in the IRS, hey, if you get something unusual in, send it over to us, and we will come up with a strategy for dealing with it. And so they're always working to foil, whatever the most recent thing we come up with, to attack, I don't know, their collection of taxes or whatever, or maintain our rights or something to that effect. And so one of the things that they've been doing, for one thing, I know that they went after my buddy Rich Standring because they did not want him to help anybody else do FOIA requests. And they got like an injunction against him requiring him to not help people do FOIA requests. Why? I think that shows you right there. They know that the purpose for putting in a FOIA request is to obtain something that could be used against them and prevent them from taking your money. And so one of the things that seems like I'm getting a lot of reports back is that people are sending FOIA requests and on a regular basis getting back at the end of the 20 days a letter that says we need more time, so sue us. And so it looks to me like one of their strategies is to just ignore the FOIA requests and also to extend until hoping that you will just forget that you even have it in there possibly. And so I'm going to propose that we use their strategy against them. Now, one thing we know about federal district courts, they're courts of limited jurisdiction. If we're going to go there, we have to have a well settled plan for being there, and that plan usually centers around we have to have a statute that gives us the right to be there. Well, Judicial Watch has been rocking their world with FOIA lawsuits. So they go against them with the FOIA suit, make them give up documents that they don't want anybody to see, and then they take those documents and use it to make change with. They take them over to Congress, they take them into court, they put it into the media, and they've really gotten to where they excel at it. So we could follow their example, and we know that we can go to district court on a FOIA suit, and they're not going to be able to just get us dismissed as long as we do a competent job on the complaint. Another thing that happened was I read a case where somebody was suing the IRS, and one of the statutes that they attempted to use was 5 U.S.C. Section 702, which is a judicial review of agency action. And what the court said in their decision, they said we do have jurisdiction to review IRS action under this statute. So that to me was pretty good evidence that we can also use this statute. So get the FOIA suit going, and then we'll find out what they did wrong, and then second cause of action be under this 5 U.S.C. section 702, and we'll point to the court to, hey judge, review this. They didn't do it right, and get a determination from them with respect to that. Which that brings me to the most fearful thing of all, and that is a threat to their job under Section 1203 of the Restructuring Reform Act of 1998. That act, that section of that act, provides that they shall terminate the employment of every IRS agent, and they can do this upon a final judicial determination if such employee commits any act or omission described in that section of that act. And then here's the scary part for them. Such termination should be a removal for cause on charges of misconduct. So what that means is no retirement for them, also no more federal government job for them. In other words, they're not going to be able to obtain employment anyplace else in the feds, and so they're going to lose their little cushy government job. And some of the causes of being terminated for cause include a willful failure to obtain required approval of signatures on documents authorizing the seizure of the taxpayer's home, personal belongings, or business assets. So we use a FOIA request to go after those signatures, and then when we find out they didn't get the appropriate signatures, then we'll turn around and we'll say, look, under Section 1203, you must terminate this employee. And let's see here. They can also be terminated for providing a false statement under oath with respect to a material matter involving a taxpayer. They can also be terminated for in violation of any right under the Constitution of the United States. And oh boy, is that amazing. Suppose they came to you and they said, hey, here's your Form 433. We need you to tell us all your assets if you want to get an offer in compromise, if you want to get a determination that it was uncollectible or something like that. So they give you this and they say, tell us every detail of your finances. Well, you know what? Under Fourth and Fifth Amendments, you have a right to be secure in your person, papers, and effects. You have a right not to incriminate yourself. So they're doing, when they give you that Form 433, what they're doing is that's called an unconstitutional condition. And so basically what they're doing is they're training the people at the IRS to violate your constitutional rights. They train them to do it. And so at any rate, we're going to pursue the vindication of our rights under this Section 1203 by getting them terminated. So then look at what else is here. Any civil right established under Title 6 or 7 of the Civil Rights Act of 1964, Title 9 of the Education Amendments of 1972, the Age Discrimination in Employment Act of 1967, the Age Discrimination Act of 1975, Section 501 of 504 of the Rehabilitation Act of 1973, or Title 1 of the Americans with Disabilities Act of 1990. That's a tall order. Tell me what IRS employee can tell you what any of the rights described in these sections, these titles are. They have no clue. And you know what? What that does is it opens the door for us to terrorize them over their lack of knowledge of our rights under these titles. Now here's what happened. I went to look to see, how they were treating Section 1203 in the case law, and here's how they attempt to defeat it. They file motions and ask the courts to rule that this did not create a private right of action. Well, you know what? I'm familiar with that phrase from doing previous research before, and so I went into case law and I looked for the phrase private right of action in the U.S. Supreme Court. And it didn't take, I think it was the first case I looked at, I came to a paragraph where the court said, we have held that there are implied private rights of action. And then that led me from there to a bunch of cases that dealt with implied private rights of action. And you know what those cases that I looked at that dealt with implied private rights of action dealt with? It dealt with all these titles right here that are highlighted in yellow up at the top. And I don't know, it might have been just the first 1, 2, 3 or something. But if I would have kept going, I would have I probably would have found most all of these included an implied right of action. So what that means is that we're going to be able to easily defeat the no private right of action. All the cases that I looked at, which was just I don't know, maybe 5 or 6, where they dealt with Section 1203, nobody made any kind of argument about implied private right of action, and nobody made an argument respecting, look at this, these other titles over here were already held to have implied private rights of action. Now, other things that we can go after them for are violations of the Internal Revenue Code. Some of you already know which ones they're violating, especially with respect to 6331, levies, Department of Treasury regulations. Oh boy, lots and lots of words there that they will violate. And then Internal Revenue Manual, and so there's plenty in there that nobody knows what all they were supposed to do. And then this is for the purpose of retaliating against or harassing a taxpayer. Well, here's what I have. I have a state case that says when they fail to follow the statute, it becomes harassment. So eventually what can be done is we can locate federal cases that say the same thing, and we'll be able to show that any time that they depart from the Internal Revenue Manual, the Internal Revenue Code, or the regulations, that amounts to harassment. Now let's see here. Let's talk about some of the cases that I found on these implied rights of action, implied private rights of action. And this is a quote from a Supreme Court decision. The achievement of the Act's allowable goal could be severely hampered, however, if each citizen were required to depend solely upon litigation instituted at the discretion of the Attorney General. So severe hampering. In this case, we're not dealing with discretion of the Attorney General. Section 1203 talks about it's the discretion of the head of the IRS commissioner, or whatever he's called. Here's another quote. While this language makes no specific reference to a private right of action, the reason I'm mentioning this is because Section 1203 does not make a specific reference to a private right of action. Among its chief purposes, protection of investors, which certainly implies the availability of judicial relief where necessary to achieve that result. And see, we got that same thing in Section 1203 because it says a judicial determination. So there's your reference to judicial relief. Another quote from Supreme Court decision: it's the duty of the courts to be alert to provide such remedies as are necessary to make effective the congressional purpose. Well, we just talked about constitutional rights and how they teach the IRS to violate your rights. So then how is it going to be that the head of the IRS is ever going to vindicate your constitutional right? He's busy training his people to violate them. So here's the plan for getting you on the IRS most feared list. I'm going to put together a monster FOIA, and we're going to raise all kinds of issues that they don't want to talk about. We're going to wait to 20 days until they send the "we need more time, so sue us" letter. And then, without delay and with planning and forethought, we'll file the suit. And we're going to file an extremely competent suit that they will hate. And we're going to be raising, for our causes of action, the FOIA suit statute. We're going to raise this judicial review of agency action, and we're going to raise Section 1203 of the Restructuring and Reform Act of 1998. The goal is to get a judicial determination that one or more IRS agents deserve to be fired. The second goal is to get a record in your file that the last person who worked it was fired. And the third goal is to motivate whoever works your case next to put you on the bottom of the pile. And after that, you can live joyfully ever after, because they'll never get around to working your case. Now, there's a problem with this type of litigation, and that is there's no damages to be had. Since that's the case, that means you want to obtain competence quickly and efficiently, be able to access what the U.S. attorneys are counting with a minimum of effort, generate litigation paperwork with a minimum amount of effort. In short, make yourself a pain in the butt efficiently. And I've come up with a plan how to accomplish this, and if you'd like to learn more, send an email to legalbear at legalbears. So the second bear is many bears in the woods. The first one is a bear in the woods.com. Legalbear at legalbears.com. And I'll get you some additional information on what the plan is.